of our how jurisdictions of our courts and tribunals have been affected by such clauses. I also hope that by the end of this webinar, all outstanding questions on multi-tiered clauses will also be answered by our great speakers. So buckle up and get ready for a very insightful session this afternoon by the great speakers amongst us. Before then, we will give an opportunity for the chairman of the Young Member Group, Abuja, to give us a short address, followed by an address by the chairman of the Nigerian branch, and then we will proceed. So Chairman, over to you.
Thank you, everyone. Good afternoon, everyone. I'm indeed delighted to welcome everyone to today's webinar of the YMG Abuja chapter in collaboration with the Ghana chapter of the Institute. Would like to especially appreciate everyone who is for being able to join in the webinar, even despite our tight schedules, to make it a success, because without you, this would not have happened. The topic for discussion today centers around practicability of the multi-type clauses in commercial agreements, as we already know. And it is strange to know that the topic reflects and will enlighten us on the need to consider the multi-type clauses when drafting agreements. It will help us in simplifying issues when drafting agreements instead of going straight to the courtroom. And we have our veritable speakers who have been carefully chosen, and most especially they are young members of the Institute, and I'm very sure we are going to learn a lot from them today. Before I hand over back to the moderator, I would like to welcome especially our very own branch chair, Chief Bola Akinola, SAN, to give his welcome address. Thank you, sir.
Good afternoon, ladies and gentlemen, and more importantly, distinguished members of the Chartered Institute of Arbitrators, Nigerian branch. I particularly salute the leadership of the YMG, Abuja, and Ghana chapters for deeming it fit to put together this program. Indeed, the choice of topic, practicality of multi-tiered clauses in commercial agreements, is highly commendable. Couldn't have come at a better time, because indeed it hits the very concept, the belly of the process of dispute resolution. Because as you all know, if you do not draft a very good clause, dispute resolution clause, you probably will end up with more problems on hand than even the dispute that you want to resolve. So taking into consideration the practicality of a multi-tiered arbitration clause or dispute resolution clause, I believe it's a beautiful one that goes to the heart of the process. Indeed, a lot of times, dispute resolutions have become a mirage because clauses have been drafted badly. We call them pathological clauses, inoperable clauses. But in a situation where you have contemplated multi-tiered clauses, it simply means you've taken a lot into consideration, possibly starting with negotiation, going on to mediation, and then possibly ending with arbitration. Of course, you put all these tiers with time lags so that the doing of any of the acts is time-based. You start with negotiations within, if you're unable to come to a fruitful conclusion within, let's say, 14 days, you go on to the next tier, mediation, and if that fails, maybe within a time frame of 30 days or 60 days, then you go to arbitration. But in order not to really take out the meat from the chosen speakers for this webinar, permit me to just welcome you all to the webinar, salute and encourage the two chapters for what they sought to do today, and to encourage for better collaboration going forward. And also wish you all happy listening and the speakers happy presentation.
Thank you so much, sir.
Ghana,
Really appreciate your words, sir.
over to you.
Great. Thank you very much, sir, for that welcome. We are very good. So moving on quickly, I'll be welcoming the chairman of Abuja chapter, Honorable Shola Ephraim Oluwanuga, for his address. Welcome, sir.
Thank you very much. The chairman of the Nigerian branch of the Charter Institute of Arbitrators, the chairman of YMG, before then the chairman of Ghana chapter, the chairman of YMG, both chairmen, as it were. I would like to thank you very much for this event, because if you know Abuja chapter very well, we've always advocated for a kind of peer mentorship or a kind of twinning program whereby chapters will collaborate under the branch. And so it was our delight to see that what I've muted, the idea I've muted with the Ghana chapter chairman is coming to light. And I will not say much about the topic of today, because the speakers, the quality of speakers that have been lined up, definitely they are very significant and they have a lot to say about multi-tier dispute resolution clause. Once again, let me thank the YMG for putting up this program, the YMG Abuja chapter and Ghana chapter. We look forward to mutually beneficial relationships as we progress in this journey. Thank you very much. God bless.
Thank you very much, sir, for that welcome address. Thank you very much, sir. And moving on quickly, we'll be having YMG Chair Nigeria, Mr. Mubo, for his room.
Good afternoon, Babayemi, the branch chairman, Chief Bola Akinola, Senior Advocate of Nigeria, Chartered Arbitrator, the Abuja chapter chair, Honorable Shola Ephraim Oluwanuga, Fellow of the Chartered Institute of Arbitrators, my vice chair and chapter chair of YMG, as well as the Ghana chapter chair. I say very good afternoon to all of you. I also say very good afternoon to all the attendees that are here. I will not wish to speak more than my bosses have already spoken, but just to encourage you to listen with rapt attention. The faculty has been carefully chosen, and I'm sure they will do justice to this topic, both the speakers and the moderators. And I just encourage both the chapters to keep up the good work, and let's all enjoy the session that we're about to listen to. Thank you very much.
Thank you very much, Mubo, for that opening remark. So we're moving on. Thank you very much, Mubo, for the opening remarks. So we're moving on quickly. We have two experienced arbitrators that are ready to take us through the journey, a quite interesting journey of the multi-tier clauses in commercial agreements, dispute resolution clauses. Please don't be in a hurry to leave. Ensure that you are listening and you are learning. It's going to be a very, very interesting one where you understand the rationale behind these clauses and the framing of these clauses. So the discussion is going to be interactive, and then you'll be able to learn and relearn the best way forward with regards to multi-tier clauses in commercial agreement. So I'll be reading the profile of the first speaker. Her name is Amorkor. Has extensive experience in commercial litigation, international construction disputes, and arbitration involving complex financial and construction issues. Amorkor is an alumnus of Slaughter and May Explore Program and the Africa Arbitration Academy. She recently completed an International Lawyers for Africa secondment program with Hogan Levels International LLP in London. While there, she was involved in disputes in the finance sector, hospitality and entertainment, among other areas of law. She has held leadership positions in arbitration career and currently serves as the secretary to the Executive Council of the Lagos Courts of Arbitration, Young Arbitrators Network. She's also a steering committee member of the Charter Institute of Arbitrators, Ghana chapter, as well as the secretary of the chapter. She's also a Delos guide to arbitration places, Rivera for Ghana. Amorkor holds an LLM from Queen Mary University of London, UK, an LLB and a combined degree in applied chemistry and environmental science. One of our passions is supporting SMEs and startups to manage their disputes to remain sustainable and profitable. Ladies and gentlemen, please welcome Amorkor.
Many thanks, Yemi. Thank you for the kind introduction, and good afternoon from Accra to everyone.
Good afternoon.
Good afternoon. Getrude, please.
Okay, so as we mentioned earlier, we have two amazing speakers. The first one is Na, and the second one is Marx Ikongbeh. Pardon me if I don't mention the name right. Marx is a founder of Everlaw Associates. It's a fast-growing commercial law firm with offices in Abuja and Lagos, Nigeria. He is a 2018 recipient of the Esquire Law 40 Under 40 Award for young practitioners shaping the Nigerian legal profession. Marx is a notary public and a member of the Chartered Institute of Arbitrators, UK, and the International Bar Association. From a background in commercial litigation and commercial corporate practice, Marx now works extensively in the field of arbitration, technology law, and intellectual property law. He's the International Chamber of Commerce Young Arbitration and ADR Forum Rep for Africa, and is listed on the panel of neutrals of the Lagos Court of Arbitration and the Federal High Court of Nigeria ADR Center. Marx acts as counsel in arbitration and sits as an arbitrator. He particularly advises and acts for local and foreign clients on post-arbitration proceedings. We are happy to have you, Marx, and we know that by the end of our discussion today, we are going to feed from your depth of knowledge.
Thank you very much, Gertrude. It's really a pleasure to be here, and you got the name spot on. And I must also add, I've never had anyone read my CV so well, even though I wrote that, but I mean, you read it so excellently that, it sounded really good. Thank you.
Thank you too. So zooming in onto the main thing, practicality of multi-tiered clauses in commercial agreements. I will ask, or one may ask, what is this multi-tier clauses in commercial agreements? What is it at all?
Okay, so like Chief mentioned earlier in his speech, arbitration clauses or dispute resolution clauses are a pith to resolving disputes, and if you don't get it right, it may end up becoming the dispute instead of the main issues between the parties. So it's very important to get it right. So these are clauses which comprise of steps with various alternative dispute resolution techniques like mediation, negotiations, expert determination, and so on and so forth. Now, in these clauses, arbitration and litigation it becomes the last step in the event the dispute cannot be resolved by all these preliminary ADR efforts. They are also referred to as escalation clauses. Sometimes people refer to them as escalation clauses, multi-step clauses, and they are also known as a cooling off period for the parties in trying to resolve their disputes. Now, the main issue here, or the point, is to offer parties the opportunity to settle their disputes outside the arbitral tribunal space or the courtroom, depending on which last resort they decide to settle on. Now, the phases that these parties agree on are independent and distinct from each other. Parties will usually proceed to the court or arbitration should the phased system fail to resolve the dispute. Now, you would realize that in some commercial agreements, just to give you a very simple example of what a multi-tier clause looks like, you realize that parties will say in the event there is a dispute, you would like to first of all try amicable resolution, and if that fails, they would want to try mediation or negotiations, not to equate the two, but just to give examples. So they would like to try either amicable resolution or mediation or negotiation, and if that fails, they move to arbitration. Mind you, these are all supposed to be done within reasonable times, and that depends largely on the parties and what they choose. This is at its simplest what you call a multi-tiered clause. They are increasingly used in long-term and complex construction and engineering contracts, which are basically, they basically count on the constant cooperation of the parties throughout the duration of the relationship or the agreement or contract. And I always say to parties that once these clauses are drafted in an operative way, the clauses should be respected and enforced as the choice of the parties. Thank you.
Thank you very much, Na. That was a very deep discussion on what multi-tier clauses are. But then I know you mentioned a few of why we should include such multi-tier clauses. Marx, in your estimation, why do you think it's important to include multi-tier clauses in commercial agreements?
Yeah, thank you for that question, Gertrude. I mean, building on the very excellent foundation laid by now, the idea is that when you think about arbitration, even though there's, I mean, the purist would insist there's a difference between arbitration and ADR. So ADR has a full basket of other options for resolving disputes. But the whole idea is that in the first place, why people have chosen arbitration is because they feel they don't want to have just one option to resolving their disputes, which would have been litigation. So that same sentiment that led to the desire for commercial parties to have alternative, and options to resolving their disputes is exactly the same reason that has also brought about multi-tiered clauses. So people recognize, for instance, that disputes come in types and shades. Not every dispute, for instance, is really suited for the adversarial nature of arbitration and litigation. So if that is the kind of dispute that arises in a contract, then if you have only an arbitration clause or a litigation option in that agreement, it means you are forced to railroad that dispute into a door that is not the best door to resolve it. But having multi-tiered clause just ensures that a dispute could be cut out at its own level. So, yeah, I mean, sometimes it just needs high-level management of both parties to sit down and negotiate. That could be the first tier, and that dispute could be solved at that point. Or it could go to mediation, and then because there's an independent third party who comes to bring some sense to the table, parties resolve at that point. And then if that fails, then it means indeed this dispute is troublesome enough to move to arbitration. There's also, of course, the cost or the economic side to it as well. The fact that resolving a dispute at the negotiation stage or the mediation stage would typically be cheaper than at the arbitration stage. So that is why, I believe those are some of the reasons parties would opt for having multi-tiered clauses in their agreements and not just limiting themselves to the sole option of either arbitration or not having arbitration at all and then just jumping straight to litigation.
Okay, thank you very much, Max, for that answer. Moving on quickly, same with you, Max. In your discussion, you've given us some of the advantages of multi-tiered clauses in commercial agreements. What will you see at the downsides? Because I mean, parties, when we're trying to include these clauses, we're looking at what will benefit the clients at the long run, right? So we need to weigh the options. So tell me why I shouldn't include a multi-tiered clause in my commercial agreement.
Yeah, thank you very much, Yemi. That's a really good question. And I'll tell a practical story to drive the point home. Now, so we had a transaction which was not really high value in that sense of it. And we had a multi-tiered dispute resolution clause in that agreement. So by the time a dispute arose, it was actually a joint venture agreement, and a dispute arose. And my client now asked, okay, give us a rough case scenario along with cost implication of having to resolve this dispute in terms of the clause we have in our agreement. So at that stage, actually, we had already triggered the first layer, which was negotiation by, and the agreement was very specific that negotiation must be between the chief executive officers that they must be present in that negotiation meeting. So that's just to make it clear that it would have to be a high-level negotiation. So negotiation had obviously shown it was going to fail. So he wanted to know what the cost of mediation and possibly arbitration would be if we went through the process. And by the time I got back to him with what would have been a cost estimate based on the institution we chose and based on their, the cost of that institution in terms of institutional cost, and then I gave an estimate of what I expected the arbitrators and the mediator might also charge. What happened was that after a while, for like a week, I didn't hear back from the client. And after a follow-up, what I heard was that they had gone to their mosque and they had their imam settle their dispute. So sometimes, if the dispute is not complex enough, then you don't need a multi-tiered clause. Yeah, and I mean, if it's a straightforward dispute, then perhaps you just want to go straight to arbitration, or you want to do mediation alone, and just leave it at that. So one downside would be where the dispute is not complex enough. And then another downside will also be that there's also a time element to the multi-tiered clause. So sometimes if the transaction, for instance, is a time-sensitive contract, then you might not have all the time to begin to trigger each step of the multi-tiered clause. So there could also be time factor and the cost factor as well. So these are things should be considered.
I think to add to what Max has just said, it all goes to the cost situation. It depends on how the multi-tiered clauses too are drafted. If parties draft it in a very vague, ambiguous manner, it tends to have complications at the end of the day, and all the most important things get lost on the parties. So it is very important to understand the practicality. If you don't understand the practicality of the clauses, and you just adopt them just like you see in other contracts and all of that, you would not get the benefits of what the multi-tiered clause is supposed to do. And honestly, in practical situations that I've encountered, when you have a transaction and the consideration or the amount involved should a dispute arise is not so huge, I usually would not even encourage you to go for arbitration in the first place. And as much as possible, even if you want to consider multi-tiered clauses, at the very least, if you want to try amicable settlements, and if that doesn't work, you just go straight to your litigation and then take your money, because let's all agree that, let's all confess, arbitration is very expensive. So if the issue at hand is not a huge amount, then once you start using this phase system, you realize the complications and the costs that you would incur will be more than the amounts that you're going for.
Okay, thank you very much. So we agree that cost is always the driving factor when it comes to picking this multi-tiered. So I'm going to stay with you now. So you talked about drafting these clauses, right? So now, what would be the best strategy in drafting these clauses? So say I'm a lawyer that's giving a commercial agreement to draft, and I get to dispute resolution clause. What should I put at the back of my mind? What should I add? What should I include? What should I remove? How should I frame it, such that when there's a dispute, parties will be able to understand that this was the intent of the parties at the time they're signing the agreement. So if you just take us through that.
Okay, so I would say that parties should consider the practicality of each phase that they want to agree on settling their dispute. So, for example, if you have you are negotiating a commercial agreement and you are looking at the dispute resolution phases, you look at the type of transaction, first of all, that you are into, and then the practicality of if you want to choose mediation or you want to do expert determination, you need to look at the practicality of that particular ADR mechanism that you want to use before getting to arbitration or litigation is very important. You must ensure not to adopt too many of the mechanisms, again, depending on the transaction that you are doing. So for example, for construction-related transactions or agreements, you realize that these are very complex agreements. And then when you look at the FIDIC forms, for example, the 1999 form, for example, they have a well-structured dispute resolution phase system for parties to follow, or unless, of course, parties decide to change the particular, the general conditions of contract and their particular conditions of contract to that effect. But it's very important to understand the transaction that is before you, and then the practicality of the phases that you are choosing. Otherwise, like I always say, you will end up being lost on the parties at the end of the complications that it would come with. It will be more than the disputes that you are going for. Also, in drafting them, another strategy that's good to adopt is the timelines, the reasonable timelines that you need to attach to each of the phases, so that you don't end up delaying at one place, which will compel another party to rush to either arbitration or court and all of that. So you need to be mindful of the timelines and ensure that in drafting it, you are drafting it in mandatory terms and not just using may. Always try to adopt the shall language so that it becomes binding and enforceable at the end of the day.
Talking of enforceable, Max, are these clauses really enforceable? Or how has it been? Has the courts enforced such clauses whenever they arise in the resolution of disputes? Are they enforceable at all?
Yeah, thank you. Yeah, so the thing with multi-tiered clauses is that they're just like any other dispute resolution clause or like an arbitration clause. They are enforceable, and the strength of their enforceability actually arises from contract, from the law of contract. So just the way every other term in the contract is enforceable, say the term to, the term to pay a price or the term as to the time of delivery, it is actually absolutely in the same light that multi-tiered clauses are also, also have the same force of enforceability. So essentially, it is based on the contract with the parties. But you could, however, say that multi-tiered clauses, like arbitration clauses, enjoy a higher, level of enforceability, because we know, of course, the principle that arbitration clauses actually stand separate from the agreement. So even if there's a problem with the underlying agreement, the arbitration clause still retains its enforceability. So it tells you that they actually have that power of enforcement. But there was something Na had mentioned when she spoke about. Now, usually where the problem comes with the enforceability of these clauses is usually not about whether the whole clause is enforceable, or whether you must take each of the steps consecutively in the exact way the agreement has listed it. Now, with that comes some element of flexibility, I would say. The reason being that it is known that easily multi-tiered clauses, one of the drawbacks you could say is where it's not drafted with precision. I mean, the chair of the branch actually also mentioned that where there's no precision as to the timing of those events, then it could easily become a tool for a mischievous party to use to delay, performance of the agreement and just let things linger on, for a long time. So I would say from the enforcement point of view, I believe the best practice, which is what courts that really are dispute resolution friendly would adopt, is to give some flexibility. So even if there's evidence to show that parties perhaps skipped one of the steps, then the question will become one of waiver, which also is a contract principle. So if a step was skipped and you did not immediately challenge that, and you waited till the end of the process, and then suddenly you wake up and said, oh, after a binding arbitration award has been issued, and you just go and say, oh, I just remember, before we got into mediation and got to arbitration, there was no high-level consultation or negotiation as provided in the clause. Therefore, this arbitration was, proceeded, and got to conclusion without jurisdiction. So that becomes a challenge if you do not raise it before the arbitral tribunal and you are throwing that up for the first time at the point of recognition and enforcement of award or bringing a set-aside proceeding. So at that point, I believe some flexibility will be introduced by the principle of waiver to say, look, if there was a step missed, then you ought to have raised it immediately you got to the next step. So if negotiation was missed, the moment you got before the mediator, you should have raised it and said, look, our agreement said 30 days negotiation window, that has not been fulfilled. Therefore, this mediation cannot go on. And of course, a wise mediator will pause at that point and send you back to have that negotiation. And if it fails and that time elapses, then you can come. So same thing also with the arbitration. So that would be one of the tricky places where one has to really watch it. But of course, I mean, it's not, of course, commercial wisdom just says avoid even getting into that sticky situation where you have to argue. So ensure you always follow each of the steps to avoid getting to where you have to start arguing, about whether jurisdiction has, there's no jurisdiction because one of the steps was missed. But as to the principal question, multi-tier clauses are absolutely enforceable on the strength of contract between the parties.
Thank you very much. So in addressing the question on enforcement, you kept mentioning steps. So how many steps are enough for ease of enforcement? For the purpose of enforcement of a multi-tier clause, how many steps, or if I may use tiers, are enough for ease of enforcement?
Okay. So when it comes to the number of tiers, that's really a matter for negotiation. And of course, some of the factors we had mentioned earlier should drive your discussions around that. So typically, when you say multi-tier clause, typically has 3 layers or 3 steps. That should typically be some amicable negotiation. Usually, some people call it consultation, and then there would be mediation, and then there would be arbitration. So typically, it's 3 steps. But of course, some contracts would have different kind of steps. So I'll give a practical example of a contract that involved the buying of minerals. So they had multi-tiered clause, but they inserted what I would call a clause, a step 2B. So that step 2B is that after the mediation, if parties still are not able to come to an agreement, then if the question standing out between them is as to quality of the minerals that was supplied, then that mineral should be submitted to a named laboratory that would carry out tests and give a result back on the quality of that mineral. And the result they give back will become the determination of an expert and would be binding on the arbitration when they proceed to arbitration. So that's kind of 4 tiers there. But of course, people could design more than 4 tiers, even though I'll be surprised in practices. I don't think I have ever seen anything. I don't know if I've not seen anything go beyond 4 tiers. Typically, I've not even seen anything really go beyond 3 because, of course, you don't want to prolong the process for too long. So maybe now give us insight if you have the 17-step clause.
That is honestly, it's nothing I've seen before, and I don't think it's even practicable. But I also say that it depends on the sector. And I would use the construction sector as an example and still go back to the 99 FIDIC Red Book, the way the general conditions of contracts spell out in detail and with procedures, timelines regarding how disputes are going to be settled. So they first submit their disputes to a dispute board. And once a decision is given, is binding unless an aggrieved party files a notice of dissatisfaction within a number of days. Now, if you fail to do that, the decision becomes binding and enforceable and you have to stick to it. Once you file the notice of discontinuance, dissatisfaction, sorry, you would have to go through an amicable settlement before you even proceed to arbitration itself. But like I earlier said, unless parties decide to amend the general conditions of contract, still on the different sectors, when you go to the employment sector, you see that they, depending on what kind of employment agreements and at which stage, we really look at collective bargaining agreements, for example. You see that parties adopt in-house mechanisms, which can be very long, although like they have short periods of time within which to try and resolve the employment disputes. And when that fails, they usually would commission a standing joint negotiating committee to also attempt. And if that fails, then it goes to the Labor Commission under the Ghanaian Labor Act or something. And I also see from different organizations or different treaties that we've signed across. Example is the WIPO. WIPO has recommended a number of tiers where it starts from mediating to amicable settlements, and then if that fails within 60 or 90 days, then you submit either arbitration or expert determination proceedings in accordance with their rules. So it requires specific care when drafting because of the various mechanisms within the different steps. And when drafted without that sufficient consideration, they bear the risk of being unenforceable due to lack of certainty, as Marx mentioned. Yeah.
Wow. And so if I understood what you said, that means that it depends on a particular transaction. It's a case by case base. So depending on what commercial transaction you are engaged in, then you advise the number of tiers that would have to be included in drafting of the commercial agreement.
Yes.
Thank you very much. All right. So still moving on, multi-tier dispute resolution clauses in commercial agreements. Will you say that it's a jurisdictional issue, as in whether or not it constitutes a jurisdictional condition precedent to the commencement of arbitration or maybe litigation? I would like to know the perspective from the Ghanaian and the perspective of the Nigerian. And so since now you're already on, I'll give you the opportunity to tell us how the Ghanaian jurisdiction has handled such issues, and Marx will come in with the Nigerian position as well.
Okay, thank you. So I would say that this multi-tier dispute resolution clauses is more to admissibility than jurisdiction. They are just preconditions to starting an arbitration proceedings or litigation proceedings. I say this because jurisdiction refers to the powers of the tribunal to hear the matter, and admissibility refers to whether the tribunal may exercise its power to judge the merits in relation to the claims that is before it. So it's more to admissibility, and practically decisions on admissibility cannot generally be reviewed by the courts unless there is some fundamental breach of fair procedure. This means that a recalcitrant party will not have the opportunity to reopen admissibility issues in the courts as a tactic to delay or prevent enforcement. And this is what happens in the Ghanaian courts. And I would say that notwithstanding, parties are also likely to proceed with compliance with their dispute escalation clauses to the extent possible, as it will be still open to the arbitral tribunal to determine it as it deems fit. So it means that the tribunal is empowered to deal with the issues, like I've stated. This could entail parties incurring additional cost and delay, and even potentially having to recommence the disputes. And of course, it entails adverse consequences or stay of proceedings to follow for the party in default to comply. Now, the English courts, just like the Ghanaian courts, have always upheld that it is a precondition to commencing arbitration proceedings or litigation proceedings. They have declined to set aside an award on the basis of failure to mediate a dispute before referring to arbitration. So that's why I say that it's just a precondition to invoking the jurisdiction of the court, and not necessarily a jurisdictional matter. It's more of an admissibility issue than jurisdiction.
Marx, is it the same in the Nigerian jurisdiction?
Yeah, so yeah, so it's largely what Na said, because I mean Nigeria and Ghana all draw from the common law, the English common law. So they are more often than not likely to follow what the common law has said. But added to that is also, in addition to that, is that in Nigeria lately, the courts have become what I almost call ultra arbitration friendly. I mean, there was a time where they were accused of not being friendly to arbitration or alternative dispute resolution. But I think we have come to a point now where they have swung all the way to the other side of the pendulum, and it is almost sometimes getting to the point where it almost looks like the courts have gotten too arbitration friendly, that they are ready and willing at any point in time to waive out anything out of the way that will stand in the way of allowing an arbitration agreement, to be enforced. So I would not expect at this point in time that any Nigerian court would allow a mischievous party get away with arguments on jurisdiction bordering on multi-tiered clauses of saying, look, the arbitration never had the jurisdiction to proceed because negotiation was not triggered, or the negotiation that was had did not have in attendance people specifically that I mentioned. Like, I always say, personally, I always like to ensure that in a multi-tiered clause, when you talk about the negotiation, insist on what that negotiation should be, who should be in that meeting, because a lot of times parties stall. Somebody comes to that negotiation meeting who has the powers to make a decision and bind the company. And on the other side, across from the table, is somebody who is simply saying, okay, I have to get back to management to confirm if that is possible. That, of course, frustrates negotiation. So I would be surprised if any court in Nigeria, considering how far our courts have gone, our Supreme Court has gone really far in encouraging arbitration and in dissuading parties from raising objections after an arbitration award has been entered. However, there was a point now mentioned, which is interesting. It now becomes an issue of if a party raises a challenge to jurisdiction of the arbitral tribunal on the basis that the multi-tiered clause maybe was not properly observed, then what happens at that point is that the arbitral tribunal, in my opinion, has to give an award on that, because that becomes a substantive issue. It can't just rule on that using a procedural order alone, because if you use a procedural order, then it means there's no recourse to court against that procedural order. But if the arbitral tribunal has to issue a partial award on that question of jurisdiction, then it means it is open to the party to now challenge that, of course, by way of set aside, not in terms of appealing for the court to review the substantive decision of the arbitral tribunal, but the court, it could. So in effect, what I'm saying at the end of the day is that there's really no way to challenge, the decision of an arbitral tribunal in terms of the substance of its decision on whether it has jurisdiction or not. So I'll, at that point, be agreeing with Nad. As far as I'm concerned, even the principle of waiver also comes into play, because more often than not, people will never complain until the final award goes against them. Then suddenly they wake up and remember that, oh, when we had the negotiation meeting, the MD wasn't present. So therefore, we are going to court to set aside this arbitral award because there was no jurisdiction in the arbitral tribunal, since the negotiation meeting that held was not in compliance with the agreement of the parties. I would believe that at that point, any decent court would shut down that argument and say, no, you had the option of raising that immediately. You went for the mediation or you went for the arbitration to be transferred. And since you did not do that, you have waived your right to raise that argument. So that for me would likely be where I believe I would see the courts go in that direction. But I see a hand has gone up. So I don't know if the moderators maybe at some point would let Mr. Chikwe speak. I mean, he's a very experienced arbitrator, so I know he must have something in the bag in terms of what he has seen in the Nigerian courts. So moderators, over to you, and of course at your discretion.
Okay, so I think we will allow the hand that is up to ask a question or is a contribution. Would like to hear from you.
Thank you very much, Madam Moderator. Thank you very much. I want to commend yourself and the entire team for putting this together and for sharing with us the benefit of your expertise. I just want to provide my own insight into the question that you asked. The two speakers, whether or not escalation clauses or multi-tier clauses to raise either procedural or judicial objection. My understanding is that each of those items the parties agreed to represent a contract on their own, and it is required for parties to comply with the requirements of those contracts. If parties have said that when a dispute arises, they will negotiate, they will mediate, and then they will arbitrate, it is incumbent on parties to comply with those requirements. And it is part of good practice for every arbitrator in your award to specify that parties have complied with the requirements of the agreement to arbitrate with regards to negotiation, mediation, and then arbitration. So yes, my straight answer is that it raises a judicial issue. Non-compliance with any of those heads raises a judicial issue. And that is why good practice requires that parties must comply, and the tribunal must also specify in the award that there's a proper compliance. Thank you very much, ma'am.
Thank you very much.
Thank you very much, Mr. Amarteifo, for that wonderful perspective. Yeah, so please, Getrude, over to you.
Yes, sure. So if you have any questions, you could either raise your hand or you can put in the chat either privately or to everyone, and then we'll address it. There will be a time for Q&A, and then it will be addressed. Yemi, please, over to you.
Okay. So Max, I'm going to come to you, right? Multi-tiered. Most times, most people, when they hear multi-tiered, they start from 3. Most multi-tiered clauses start from 3. Now, is that a given? Like, and now asking the same question, maybe in Ghana, it's different. But most times, most clauses that you see starts from 3. Is it a practice, or is it just that you have just adopted it, or is it law? Or will you say that multi-tiered clauses can start from 2? I mean, it says multi, does not mean multiple. Yes, so Max.
Yeah, thank you, Yemi. Yeah, I mean, that's actually a very practical question. So, I mean, a lot of the popular multi-tiered clauses, for instance, the ICC multi-tiered clause actually has that formula of 3 as well. So the negotiation between the parties, and then what it says is the second tier, it calls it ADR. So, but by the ICC rules, if you have not nominated which ADR you mean, then by default, mediation is the ADR that ICC would pick. But you could, of course, select any of the other ADR options you have, and it mustn't be mediation, and then, of course, arbitration. So typically, that's the most common formula, but they are very unusual formulas. So, for instance, I've read of an Indian case where the multi-tiered clause was a very funny multi-tiered clause. So it was, I think it was negotiation, it was arbitration, and there was a funny type of arbitration that was supposed to be like an appeal. So if any of the party feels aggrieved with the decision of that arbitral tribunal, it could, I mean, the only word I could call it, in terms of what the Supreme Court judgment of India said, was that the parties were allowed to now appeal from the award of that tribunal to another arbitral tribunal, also specified how that second arbitral tribunal would be appointed as well. So, I mean, and then there are other formulations. I've also seen a formulation, I think I read the case, it's a Singapore case, where what the multi-tier actually was, there were all negotiations, but different layers of negotiation. So a negotiation with a lower level team, a negotiation with a higher level team, and then a negotiation that involved parties from the Chamber of Commerce of that particular sector before they could go to arbitration as well. So there are many formulas, and but like I said, the very conventional we see typically is the 3. And of course, one of the points you have made is because you don't want to make it too complex. Because the more complex it is, I mean, it takes more time, it becomes more expensive. So typically 3 is good. I mean, and a lot of agreements also, 2 might just do it. You don't have to go to 3. So there's no magic formula about 3 really.
Now I want to hear your thoughts on this.
Yeah, I mean, I totally agree with Marx. There is no particular formula to this. Like I mentioned earlier, it also depends on the kind of transaction that's in the industry. I gave an example in the construction industry, and I have seen a lot of institutional arbitral institutions and their draft arbitration clauses, like the LCIA. They have about 3 tiers of dispute resolution clause. I have seen one practically from normal commercial agreements where they've adopted just 2. They started with amicable settlements for 30 days. And once that failed, they moved straight to arbitration. So there's no 1 or 2 ways of doing that. And there's no particular law in Ghana that spells out the number of tiers. No, it's not, it doesn't work like that. It really depends on the transaction and the industry in which the parties are operating. And also, like I said, you need to look at the practicality of the phases that you are adopting with the kind of commercial or the business that you are doing. You just don't have to adopt it just like that, for lack of better expression. Yeah.
Okay, thank you very much. So now staying with you, so I'm going to narrate the situation, right? So that you give us your opinion on it. So if a party starts an arbitration without going through the contractual provisions that stipulates for negotiation and mediation, now, does that affect the jurisdiction of the tribunal? Will you say that affects jurisdiction of the tribunal? Then let me hear your thoughts on that.
Well, yeah, I always primarily say that it depends on how well the clause is drafted. So if you have a well-drafted clause that is operative using the mandatory drafted in mandatory terms with the reasonable timelines in place and all of that, and you fail to comply, and you go to court or you go before a tribunal, definitely, if an objection is raised, the tribunal would object to proceeding with the matter, because then you need to comply with the phases that you have agreed to. So the court or the tribunal is going to send the defaulting party back to go and comply. Typically, that is what happens. Now, in situations where the clause has been vaguely drafted, I've seen so many where people adopt multi-tiered clauses without timelines. So they say amicable settlements, and once that fails, we move to mediation. And if mediation fails, we move to the court or the arbitral tribunal. So you realize that they might have started with amicable settlements, which I have seen a few, and then the communication is not flowing well. One party is not agreeing with the other, and then the other party thinks, you are not responding to me, there's too much delay. So the other party goes straight to court or goes to the arbitral tribunal. And then the party who has been lacking behind will come with an objection that we have a phased dispute resolution clause for which we are adhering and not done. So this jurisdiction is not right for us to be here at this point in time. In situations like that, I think that the courts will also have to look at the commercial dealings involved here, not just the law. So for the Ghanaian courts, they are looking at the reasonable time lapse here, and whether the party defaulting has intentionally decided not to comply with the phased system. And based on that, the court is going to rule on its jurisdiction or otherwise. And the same happens before the arbitral tribunal. So the reasonable time lapse factor is very important, as well as the intention of the parties to really and truly decide not to follow the phased system as agreed to.
Okay, so now, if I get you correctly, right, you're saying that once parties fail to adhere to the clauses and contractual provisions, the consequences is that the arbitration cannot proceed. So the arbitral panel cannot decide on any of the matters in the arbitral reference.
I mean, like I said, so depending on how well it is drafted. So if you have drafted an operative clause, the arbitral tribunal would have to let the defaulting party go back and adhere to whatever they have agreed to and enforce appropriately in accordance with the agreement, as opposed to assuming jurisdiction only because a party has come and is complaining about delay. So the court is going to look at how well the agreement has been drafted or the multi-tiered clause have been drafted. If it is a well-drafted clause and the terms are clear, and I give an example of a Ghanaian case, BHM, sorry, let me get the case correctly so that I don't deceive you. BCM and Ashanti Goldfields, where the Supreme Court has been clear that in agreements where a specific power has been conferred upon parties, it's necessary and even imperative for the party purporting to enforce these clauses to ensure that the condition precedent to such enforcement of the power are fulfilled. So as much as possible, the tribunal would have to let the defaulting party go back and adhere. Now, in situations where you have a vague draft, like I explained, where there are no timelines, parties have just agreed that we are moving from A to B and to C. There are no timelines to it. There's no certainty. Then it behoves on the tribunal or the courts to use the reasonable time lapse to determine whether it can proceed or still ask the defaulting party to go back and look at the intentions of the parties in terms of who is really trying to, whether or not it's a party's intention to delay or has decided to default in terms of the agreement.
Okay, thank you very much. Now, so Max, I'm going to come to you, right? If a party does not comply with the multi-tiered clause, how should the breaching party be sanctioned? Max, before you answer, please, if you have questions, kindly drop them in the comments section. We will attend to them after we're done with this round of questions, so we don't have interjections intermittently. Please do drop them in the comment section, and we'll get to them after the session. Thank you very much. So, Max, how should they be sanctioned? Is sending them back to adhere to the contractual provisions enough? Does that serve as enough deterrence, or should arbitral tribunal do much more than that? What would you suggest, Max?
Yeah. I mean that's actually a practical issue. What should an arbitrator do when it's raised before him that the pre-arbitration procedure, sometimes a catch-all way to describe them, have not been fulfilled. I mean, it's just like anything else. And thank Mr. Babayemi for his intervention. Yeah. So, I mean, best practice is that the arbitrator before whom that objection is taken should look at it critically. In fact, as a matter of fact, like Mr. Babayemi even said, even if parties did not raise it, in the award, the good arbitrator should, looking at the dispute resolution clause that is before him, should even stipulate in his award to show exactly that parties have complied with those steps before they got to arbitration. So I think the first and the best solution is the moment a party raises the fact that the opposing party has not complied with the steps required, then the arbitral tribunal should, of course, at that point, pause the proceedings and send parties back. So it was a negotiation that was not concluded. It's better to send them back so that they go and conclude that negotiations, or ensure that the people who are supposed to be in those negotiation meetings, or however the parties agree to structure that negotiation meeting, that indeed parties complied with that, so that the arbitral tribunal is fully persuaded that it's all the steps have been fulfilled before the matter has come to arbitration. Now, there could be some other arguments also that just because the arbitration or any dispute resolution clause is essentially a contract. So, I mean, the breach of a contract, of course, there are always different ways to redress it. So, one of the ways I think a party could actually enforce that is if, for instance, in relief of specific performance. So, you are saying, look, maybe perhaps you have gone before the arbitrator and he refuses, or he just believes that, look, the fact that negotiation or mediation wasn't concluded doesn't affect his jurisdiction. I would think a party actually can bring a proceedings in the court or in the high court and actually ask the court that make an order for parties to comply specifically with what was agreed. So send parties back and give an order for the arbitrator to stop any further proceedings and send parties back to the place of negotiation or whatever step was skipped in that step. So I think that would be the way. I mean, of course, generally breach of the contract will lead to damages, but sometimes in that scenario, I find it difficult to, imagine how if a person brought a damages claim because a step was missed in the arbitral, in the multi-tiered clause. I wonder how that damages will really be quantified, because the principle of damages, of course, is put a person back in the position he would have been if not for that breach in terms of monetary terms. So the question is, if the negotiation wasn't hard, I mean, in a sense, what really is the measure of damages to assuage you if the negotiation had been hard? So that could be tricky. So I think principally would be to raise it promptly before the next step of that multi-tiered clause. And then, of course, you could also use specific performance. Yemi, you are muted. We can't hear you.
Oh, sorry about that. Now, coming back to you, will you say from your experience that multi-tier clauses are causing delays in the resolution of disputes? So, I mean, I'll have to be done with clause 1 before going to clause 2. Say in clause 2, I ask for an extension, and after the extension, it still drags on before now going to clause 3, and then clause 3 is also a drag. Won't you say that? Because considering the fact that commercial transactions need to be resolved speedily because parties need to go and transact. So will you say that these multi-tier clauses are causing problems? Maybe we should just stick to one. So if after one it doesn't work, parties go and explore that means. Or you want to say we must do this at this stage?
Okay, as I've already mentioned, largely it depends on the kind of transaction that you're doing. So there are certain transactions that really you don't need a multi-tier clause to deal with, depending on the commercial issues involved. And I'll give an example of banking and finance disputes, honestly, depending on where you stand as a party, whether as a lender or a borrower. And from experience, a lot of lenders don't even like to go through all these phases. I mean, especially when it has to do with default in payments. You see that lenders would always, when negotiating these agreements, when it gets to the dispute resolution aspect, they would always push to go straight to court in the event of any defaults. They don't want to go through the phases because, to be very honest, and practically, it wastes time. Like I said, depending on where you stand as a party. If you're a lender and there is a default in payment, you are now coming to start mediation and go on to perhaps MCIArb or negotiations before you get to litigation or arbitration. So most of them really don't even appreciate the whole arbitration proceedings when it comes to banking and finance. Of course, until recently, where I see that a lot is changing in that sector. But a lot of the times, it causes delay depending on the sector that you are coming from and the kind of transaction that you are doing. I've seen a few where I've had to look at dispute resolution clauses for the finance sector, where lenders have pushed hard enough for the matter, any dispute, to go straight to litigation and not even arbitration. And even if it's arbitration, they don't even want to go through the phases of resolving the dispute before it goes in because of the delay and the cost factor. So it really depends on the kind of transaction that you are doing.
Okay, thank you very much, Na. But now in Ghana, in a commercial court especially, you file a process in the commercial court, you are asked to go for a mandatory pre-trial conference. Will you say that that is more of a multi-tier dispute resolution as well?
Well, to a large extent, and perhaps to look at what presently happens, the rules have changed. Now it is not mandatory, because when you look at the language of the rules, it says that parties may go for pre-trial. So you realize a lot of the times when you go before the commercial court judges for pre-trial, it moves on very quickly. They look at the demeanor of the parties and the way and manner they are going about the pre-trial. Are these parties who are willing to settle? So one or two appearances, the judges proactively know that these people want to go for trial. In fact, a lot of the times the judges help a lot and they give a lot of suggestions as to how parties can go about it, let them know the practical concerns. If you proceed to litigation, these are the things that you may encounter. This is what is going to happen. So why don't you attempt this? Why don't you give it a try? But it is not mandatory. It's now very relaxed, unlike the old rules where you are mandated to go through pre-trial. And I would say, yes, it's a phased dispute resolution mechanism, so to speak. Yeah. A court-connected kind of ADR. Yeah.
Okay. Marx, in Nigeria, do you also have a similar provision where parties who subject themselves to litigation in the commercial courts are also asked to go for pre-trial conference?
Yes, we pretty much have same in most of the rules of the courts in Nigeria. Of course, unlike Ghana, Nigeria is a federation, so it means most commercial disputes, could be resolved either at the Federal High Court, which is one court all over the nation, or it could be at the state high courts, which is depending on the 36 states in Nigeria. But I think practically now we don't have any rules of any of the courts in Nigeria. Currently does not have a pre-trial conference facing it. Then there's also what we call screening for ADR. So most courts actually have provisions that says cases should be screened, and cases that are deemed to be suitable for ADR should be sent to ADR. So for instance, practically in the Lagos jurisdiction, I think they have almost what seems like a standing order that all defamation cases should be screened and sent to ADR, because the thinking is that most defamation cases is because the person is hot about his reputation. So they assume that those kinds of cases, they go to ADR. A skilled mediator might be able to make parties see reason why looking for his reputation and his his estimation of himself. So could you consider a little? Of course, that would not be a suitable dispute for arbitration. So again, what we have in Nigeria is what we call multi-door courthouses. So essentially, multi-door courthouse gives you multiple avenues for resolution. So at the point of screening for ADR, they are screening and asking themselves, what is the most suitable door of this resolution to send this dispute to? So like I said, for defamation cases, typically to go to mediation. But for a commercial dispute, for instance, it might be sent straight to arbitration. Because again, just following up what Na said the last time, the court administrators understand that time is of the essence in some of these transactions. So you don't want, for instance, a financial transaction, you are sending them to go for negotiation, for mediation before they finally come. Of course, interest is running, on that debt. So it means it's kind of a knife that swings both ways. So it's not really in the best interest of both parties. The sooner you resolve the dispute and you determine what should be paid and interest stops running, the better for both parties.
Thank you. We'll be moving on to the questions in the chats shortly, but I would like to ask one question. When we say multi-tier clauses, is it a form of an ouster clause? Ouster clause.
Okay,
Okay, sorry.
That's an interesting question. I don't know about Ghana, but in Nigeria, we had a lot of military coups, in terms of the government at a point. So ouster clauses is something that we associate, of course, with the military intervention in the Nigerian polity. So typically what happens is that once the military comes in, they pass this draconian law that says, look, no court can inquire into XYZ amount of things, and that outs the jurisdiction of the court. But I would say ouster clauses are really radical, and that is why even the courts, even under the military, would always construe them, with very stringent conditions. So an ouster clause, in a sense, ousting the jurisdiction of the court actually is a very radical thing. So I would say there's, a commercial agreement of parties, like a multi-tier clause, certainly will not come anywhere close to ousting the jurisdiction of the court, because even an arbitration agreement, the law is very settled, does not affect the jurisdiction of the court. The court is simply exercising the jurisdiction to send parties to comply with the agreement by saying stay proceedings to go and mediate. That is why when there's a challenge, when the person brings an objection to litigation because it's an arbitration clause, the court will not strike out the case. What the court does is to stay proceedings and send parties to arbitration. That means its decision is intact. It's simply saying honor your agreement and go to arbitration. So I'd say no, multi-tier clauses do not come anywhere close to being ouster clauses.
I think I totally agree with Marx. They are just preconditions to litigation or arbitration at the best. Even with arbitration, like he mentioned, jurisdiction is, if you are not complying, you'll be sent back, for lack of a better expression. The defaulting party would have to go and comply with the terms of the agreement. So I think ouster clauses are more too heavy a word to be put within the commercial setting. So they are just preconditions to either arbitration or litigation. Yeah.
Thank you so much. We'll move on to the questions in our chat. So the first question I see is from there are lots of questions. Okay, a question from Ali. It says that where a party raises the jurisdictional issue of non-compliance with a multi-tier clause before an arbitration tribunal, in your view, is it advisable for the arbitral tribunal to step down the issue of jurisdiction until final award, or it should be dealt with at the preliminary stage, and why? Should I repeat the question?
Okay, no, I got the question. Okay. And I see already a very excellent answer that has come from Mr. Ikongbeh. Yeah, so
yeah,
yeah, so but just even addressing it from the practical standpoint, I mean, it would be quite scary for an arbitral tribunal to choose to put that kind of point until the final award. So I mean, what happens if at the final award you find that indeed there was a non-compliance? It means that the whole proceedings actually is just been a waste of everybody's time. Yeah. So I mean, even consistent to the principles within litigation, which is established that the moment there's a challenge to jurisdiction, it has to be trashed out immediately. You can't, judicial challenges are not things you are allowed to pend until until the stage of the final award or the final decision on the issues. It is always good practice that once issue of any issue that touches on jurisdiction is raised, it should be addressed immediately and a decision made on that. So that's just a practical answer.
Okay, that's actually the case. That's what happens most of the time. Yeah.
Okay. So we have another question from Senna. Oto. She said that, will you recommend parties adopting multi-tier arbitration clauses of institutions like the ICC or the LCA, rather than attempting to draft a new one? What will be the deciding factor?
Okay, so like I've said from the beginning, you need to look at the practicality of the phases that you are adopting. So if the ICC model clause phases works for you in practice, you realize that whatever transaction that you are in, choosing mediation or negotiations is practical enough to deal with the situation before perhaps you move to mediation and then to arbitration. Of course, I mean, it's recommended to take it, but it really depends on the transaction as well, like I keep saying. So the practicality of the phases is very important, and you shouldn't just pick it and use it. You should look at the nature of the commercial transaction that you're doing and as to whether that phase system is going to work for you. It is very important. As much as possible, even if you adopt it, you can modify it to suit your purposes. So it's not like just picking it and adopting it. It really depends on what parties choose and how well they negotiate the dispute resolution clause.
Yeah, just to add to that, I agree with Na that you could use institutional rules. I mean, typically the reason is because institutional rules already have a whole body of very well-defined rules backing up that clause. So I mean, beyond that multi-tier clause alone, there's already very clear framework. So for instance, if that multi-tier clause says peak mediation, typically you find in the rules other supporting provisions that clarify those very well. And typically most rules give you flexibility. So it always says subject to the parties' agreement. This is how the multi-tiered clause works. So it means the parties now say, look, we are picking the ICC model clause on a multi-tier model clause, but we are omitting the second step, or we are reconfiguring that second step to be, this or that. So yeah, you could using institutional rules helps a lot, because it just means you can be certain that these institutions are backed up by people who are taking their time, and there's a lot of experience in how they have drafted their rules. So they already know some of the practical hiccups that could come, and they might have provided for them in their rules, unlike just adopting your own ad hoc, designing your own multi-tier clause yourself.
Okay, that is very insightful. I don't know if I've missed any question in the chat. Please draw my attention if I have. But there's an opportunity for anyone who wants to ask a question. We'll just take a few questions, and then we have 2 hands up. We'll call Nanya, Ghanaian chairperson.
Hi, good afternoon. Good afternoon, everyone. So I don't have a question, I just have a comment, and I just thought I should add to our learning. There was a question on jurisdiction, whether if someone not complying with the preconditions, for example, they are supposed to go to mediation before arbitration, if they don't comply and they raise it before the arbitral tribunal, what should be the arbitral tribunal stance? Is this something that should be determined first or added to the final award? And I just wanted to point out that there's a recent UK decision and also the practice guide by Chartered Institute of Arbitrators that issues relating to multi-tier non-compliance with a multi-tier dispute resolution clause, for example, not fulfilling the preconditions, is not an issue of jurisdiction. It's an issue of admissibility of the claim. So it is treated the same way that if you raise, so it's not a jurisdictional objection, you raise an issue as to whether the claim is admissible, i.e., is it ripe to be heard by the tribunal? And in that instance, the tribunal has to decide on that before we go on. And that's treated the same way as if you raise a time bar issue, that, for example, the claim is time barred. That is an issue that needs to be decided at the very first instance before the arbitration will even proceed, because based on that, we may decide that the arbitration cannot even go on. In that instance, if it's decided that the claim is not admissible, what then happens is that arbitration is put on hold. They have to go and fulfill the precondition before it becomes ripe for the tribunal to hear it. Thank you.
Okay, thank you very much, ma'am. Thank you very much. I think there's Lorraine. I think after Lorraine, we're done with the session. So, yes.
Yes, please. Thank you so much. And I've really enjoyed the session. I'd like to find out, a lot has been said about the time in between each of the tiers. And I'd like to find out if we've considered, or if it has been seen, an example where we say 3 sittings or 30 days. So that if 30 days is not going to suffice, as the example that Mark gave, where 30 days wasn't enough, then we look at 3 sittings. Then that could be more practical. So we can just draft something saying that if negotiation fails within 30 days or 3 sittings, depending on the nature of the dispute, then we move on to mediation or something of that sort. Please, are there any examples like that?
Yeah, thank you, Lorraine. I'll just give some, because I've had a practical experience of this. Now, what in this practical experience, the clause simply said, any dispute arising will be should be submitted to negotiations between board level members of the parties to the agreement. Then the next step now says, where there's no resolution of the dispute after 30 days, then parties can proceed to mediation under XYZ rules. Now, the challenge with that is that 30 days now, what do you compute 30 days from? So that is why it's always important that beyond giving timelines, you must always have trigger events so that it is clear. So 30 days from issuance of a notice of dissatisfaction or a notice of, of negotiation, it should be clear. Then mediation also is another problem, because I've seen also a practical case where it was also, I think was said 45 days from mediation. But appointing the mediator alone, because they selected one of the court-connected institutions to appoint the mediator, and because of the bureaucracy in that court-connected institution, it took almost 30 days to appoint a mediator. So by the time the mediator was appointed, for parties to get notification and even have, one of the meetings, they already only had 5 days left. So you could imagine what could the mediator do in 5 days. So it's also important to always make it clear. The 30 days should run from the appointment of the mediator. So these are some of the things about timing. Timing must always be tied to specific events. It shouldn't just be at large. You should tie them to specific events.
Okay, to add to what Max has said, I think sometimes it's also good when, even if you want to use 30 days and you're adopting an institutional approach, like an ICC model clause, and you're using that, like you said, it is well structured. They already have experienced mediators, experienced arbitrators for which you can choose from. So that delay is kind of well catered for or shortened, so that even though you choose 30 days, there's not so much delay in trying to just pick a mediator or a negotiator or an expert. So sometimes that's why we advise that you can adopt, when you say you want to submit to mediation in accordance with particular rule, it helps in trying to defeat the whole idea of the delay.
Okay, thank you very much, Max and Nat. So I think it's clear that we can exhaust this discussion at this point. I think one thing that is clear is that, as well regards to the time frame, is that as Naz and Max said, is ensure you have a trigger event, because that trigger event would make your clause more understandable and make it more readable, right? So I don't think there are any more questions that we can take, because we're running out of time. So I would ask now for your closing comments. Then I'll go to Max for his closing comments. Now, please.
Okay, so I would say that, like, from the beginning, it's very important to be very precise in setting when drafting your multi-tiered clause agreements. And it's always good to bear in mind the kind of transaction or the sector in which you are dealing. And I'll just state a few steps you must consider when drafting. It's very important to insert mandatory vocabulary language rather than a permissive language. So instead of using may, it's always important to adopt a mandatory one like parties shall and not parties may. It's always good to also avoid vague terms like amicable negotiations, best understandings, or good faith. The interpretation of these terms sometimes during disagreements, honestly, and from practice, could be very much manipulated, so it should be avoided. It's also good to define the time frame of each step, like we've been saying it all along. It allows each party to know how long the process will take, and it offers parties with some sort of clarity on potential limitation or time bar issues. It's very, very important when you are negotiating your multi-tiered dispute resolution clauses. It's also good to define every step in full detail. So define the process precisely, clearly set out how each step should commence and how it should be conducted, and avoid leaving the steps or matters to be agreed. Already you are beefing, for lack of a better expression. And how sure are you that at the point where the waters are deep, you would agree to a particular phase? So it is very important to do that as soon as possible by agreeing prior to the dispute. You need to improve the success of enforceability of any pre-trial step by specifying the consequences of the failure to comply with any of these stipulated steps. So I just thought I should share in a nutshell what you should take into consideration in drafting. Thank you very much.
Thank you very much, Na. We're not sure that it's very, very big. Marx, next.
Okay, yeah, thank you. So I'll just be adding to, I mean, Na has laid very good practical points. Now, one very practical point is in drafting a multi-tiered clause, I mean, and generally any dispute resolution clause, you know, I always insert a continuing obligations clause, you know, which simply says, irrespective of any dispute resolution going on under the terms of this agreement, parties are still bound to continue to fulfill their obligations under the agreement so far as they are unhampered by the dispute in question, because you don't want everything to ground to a halt just because there's a dispute being resolved, and perhaps the dispute is only not even affecting practical obligations of the parties, and then the party wants to just hinge on the fact that there's a dispute going on and wants to withhold payment or withhold other obligations. Then I believe Seibu Gumi mentioned early neutral evaluation, which is actually a very good tool in multi-tiered clause, because one of the advantages of multi-tiered clause, and in practice I've seen, is that genuinely during that multi-tiered clause, parties begin to, for instance, for the first time, really see the other person's position. And sometimes you find out that even if you ultimately get to arbitration, or you find out that at that point, issues have really been narrowed down. Some of the irrelevancies have been, moved out of the way, and parties can really focus on the dispute itself. Or sometimes in the course of that, parties find solutions. So yeah, early neutral evaluation, done by an independent third party that shows parties the relative strength and weakness of their case may persuade them not to continue on the part of this resolution and rather just come to a settlement because they find that, look, my claim might be weak even if I get there. Then the last point, Israel Usman mentioned statute bar, which is another danger you should watch out for. Particularly if you are from a jurisdiction like Nigeria, where the law is that the time frame for bringing an action in litigation in court continues to run, whether you are having arbitration proceedings or not. There are some technicalities to that, but the danger there is that if you have a long drawn out multi-tiered clause, then you run the risk that by the time you are done with that your long procedure, contract claims in Nigeria, typically most jurisdictions, you have to bring your claim in 6 years. Other jurisdictions, you have to come in 5 years. So if you fall out of that time, then you have a challenge because there's a Supreme Court authority in Nigeria where somebody tried to enforce an arbitral award after the 6 years for a contract claim to go stale. And the court said, look, you have to finish your arbitration and enforce within that window of 6 years, that your arbitration doesn't stop the time from running for the purpose of statute bar. So that's another danger you have to watch out for if you have you are setting up a multi-tiered clause to ensure that your multi-tiered clause doesn't take so long that by the time you are done, and you go back to court to enforce the award, and then there's a challenge that award is already, that award can no longer be enforced because the claim itself has become a statute bar. So those are some of the dangers that you should watch out for in adopting multi-tiered clauses. Thank you very much, Yemi.
Thank you so much. Such an insightful session from our two speakers. We know that you are living here pros in multi-tier clauses. You are going to be drafting them accurately so that drafting will come out well such that they'll be enforceable in our court or in the arbitral tribunals. All too soon will be coming to an end, but as we already know, it's a collaboration between the Abuja chapter and the Ghana chapter. And so we'll give an opportunity for the chairperson of the Ghana chapter, in the name of Nania Ankoma, to give us some closing remarks. There's a heated argument in the chat, but I believe
a very heated one.
Would have continued, but we cannot, and so we will pause here, and then maybe we'll continue on our various platforms and come to a conclusion by ourselves. So Nania, over to you.
Well, thank you everyone for such an insightful session. I mean, really, there isn't much to say. Thank you to the speakers, Na and Marx, for sharing your knowledge. Thank you to our moderators, Getrude and Yemi, for such skillful moderation. And to all participants, thank you for joining us today. I just want to say thank you to the branch chair, the Abuja chair, and the YMG chairs. Let's keep up the collaboration. Thank you.
Thank you. Thank you everyone for joining. Enjoy your evening.
Thank you,
Thank
Gertrude.
Thank you. Thank you, Noah. Thank you,
Yemi and Gertrude.
Thank you.
Thank you, everyone. Bye.
Bye.
Bye to all.
Thank you, Mr. Asaidu, for that bringing out the issue on the early initial evaluation.